because she deserves not to be detained for a second longer. As things currently stand on the 12th of August, she has been detained uninterrupted for a period of 4 months. That is 80 times longer than any of her co-accused, and which is why we were emphatic on quoting the section on equality, which is to say, if her co-accused were able to be released on bail and the state was able to oppose their bails and have its case ready on the day that they applied for bail, then there is no reason that Ms. Cholota should spend even an hour longer than she needs to. The state knew as far back that Ms. Cholota had been extradited, and that is being generous with the time, because if memory serves me correctly, it was June, and then the decision was referred to the Secretary of State, and that is when submissions were asked. But the decision in and of itself was made towards the end of July. So from the end of July, they have known that she would be back, that any and every opposition that they would have to make, there's nothing that we have raised in the papers that is new that the state has not known, nor that we hadn't raised in prior conversations with the state. But most importantly, Your Worship, we had a conversation telephonically with the state prosecutor, Mr. Donation, and on Friday. And he, as far back as then, confirmed that they were going to be opposing bail. And so he could have prepared himself, interviewed the investigating officer. That did not warrant sight of our bail application. And he could have had his case ready so that we are able to proceed. But that was not the case. And so our submission is that it cannot possibly be said that his wanting more time so that he can go and do his job is sufficient to justify Ms. Cholota's arbitrary detention for longer than need be. Now, to the regular person, perhaps a night in jail is nothing less than a night in jail. But for someone who has spent 4 months in prison, an hour longer than need be in jail is too much. And so we really implore this court to consider itself bound by the Constitution, and also to consider that the interests of justice have never been more necessary to call in than in this matter. There is no reason that Ms. Cholota should be in jail, and there's no reason that she should be in jail overnight so that the state prosecutor can do a job that he has known days in advance that he needed to do. The submission that we need to file a proper and final affidavit and that we need an opportunity to reply simply cannot stand. It is now 10:30. This can be done towards the end of the day. They can come back with, if in fact his submission is correct, that they have been working on this, then 4 hours, 5 hours should be sufficient for them to draw up an answer to our papers and return so that this matter can be finalized. We simply cannot have it be, milady, Your Worship, my apologies. We simply cannot have it be that the state, over and above all of the disregarding of Ms. Cholota's constitutional rights, be so used to it that even now they insist on disregarding her rights. There isn't a single of the 17 other accused that has spent a night in jail, that has had their bail application postponed. Every single one of them came to this court and was granted bail. There's no reason, just cause. So the reason that Advocate Donation is purporting to advance is simply not sufficient in our view to justify Ms. Cholota going back down in those cells and going back to the jailhouse for yet another night. And we do not even know that tomorrow it might be finalized, as he says. Perhaps tomorrow, once he has decided, as he said, whether he will adduce viva voce evidence or oral testimony, if it will not again be postponed for another day. And so we cannot trust that the rights of Ms. Cholota in this instance could be said to call in the interests of justice. We simply cannot. The case law is replete with examples of the Constitutional Court time and time again insisting that a person cannot be detained arbitrarily without just cause. To detain her for a single night longer than she should, at the behest of Advocate Donation, simply does not stand in our view. That is our submission on that regard. We are of the view that if the state indeed has been dealing with this case since June, July, as they say, then 5 hours should be sufficient for them to come back and respond to an 11-page affidavit. We do not accept the request for the matter to be postponed and for bail to be heard tomorrow.